Shall I continue? And MSMEs are also particularly vulnerable as far as the recovery is concerned. And therefore, the aspect of access to credit to help MSMEs recover from the COVID-19 episode is particularly crucial. It gives me great pleasure to join forces among the UNCITRAL Secretariat and the World Bank to walk you through the MSME access to credit and insolvency aspects of today's webinar. The moderator joining me today will be Mahesh Uttamchandani. He's the practice manager for financial inclusion, infrastructure, and access in the finance, competitiveness, and innovation global practice at the World Bank Group. He manages payment and market infrastructures, responsible financial access, credit infrastructure, the Global Financial Inclusion Support Framework Program, and the Global Financial Consumer Protection Program. He also jointly leads with an IFC co-head, the Universal Financial Access 2020 initiative. It gives me great pleasure to give the floor to Mahesh to introduce this panel, where we will have 1,124 registered participants, and where we greet up to now more than 53% of female participants. Thank you very much. Mahesh, you have the floor.
Thank you. It's a great pleasure to be here, and thank you very much to our friends and partners at UNCITRAL for inviting us to present here today. It's great also to see so many friends after such a long time, and I'd like to just take a minute to wish everybody well and hope that you and your loved ones are safe and sound in this rather strange time we find ourselves in. These two topics, of course, are topics that are near and dear to our hearts at the World Bank and have formed the cornerstone of a very strong partnership we have had with UNCITRAL over many years. Some of you will know that after the Asian financial crisis, the Financial Stability Board asked both the World Bank and UNCITRAL to serve as co-standard setters in the area of insolvency and creditor rights. And this has led over many years, and with the participation of many of you, and of course led by the member states, the development of several instruments that guide policymakers around the world in developing their secure transactions and insolvency systems, namely the legislative guides on secure transactions and insolvency, the model law on cross-border insolvency, and the World Bank principles on insolvency and creditor rights. And these instruments provide both an overview and a framework for policymakers to understand what their objectives might be in developing these domestic legal frameworks, but they also provide a hands-on guide to implementing these frameworks. And I think the reason I mention this is I think that in the context in which we find ourselves in this COVID crisis, these instruments and tools are more important than ever. And we find ourselves in some cases needing occasionally to deviate from some of the core recommendations in these instruments, but also to leverage the flexibility that is built into these instruments to provide guidance to countries on how to respond to this COVID crisis from an access to finance perspective. And this is something certainly we at the bank are heavily engaged in. We expect that we will be lending approximately $60 billion over the next 12 months as part of our COVID-19 response. And much of this lending involves policy advice and working hands-on with governments on insolvency and secure transactions frameworks to promote access to finance as part of what we hope and anticipate to be the COVID recovery that should come eventually in many countries. But let's make no mistake, this is a health, a social, and a financial crisis for most countries in the world. And the challenge that it poses to access to finance is great. We know that going into this crisis, access to finance was heavily correlated with the quality of one's insolvency and secure transactions legal regimes. But that in many countries, those regimes were somewhat limited and were certainly operating below what we would expect to be best practice, and so was therefore constraining access to finance significantly. With this crisis, countries have had first and foremost to deal with the health aspects, but are starting to very much feel the effects of the financial aspects of this crisis, which is having a restricted effect on access to finance. We project a 25% drop, for example, in global remittances, which are a major source of finance for the poor around the world, and the potential risk of many tens of millions of citizens falling back into extreme poverty. So it becomes even more important that policymakers respond to this crisis with the appropriate policies that will stimulate and help access to finance grow. And I want in particular to highlight the risk that this crisis is posing for women. We, as part of our work on financial inclusion, have worked for many years with many of you, many partners on this in this event today, on increasing women's economic participation. But going into this crisis, there was already much to do. A billion women worldwide do not have access to any sort of formal financial service through which they could not only borrow and access credit, but even make simple payments. And part of what the opportunity, I suppose, that this crisis presents is to accelerate all of our efforts on connecting more women to financial services and to the financial system. And we know that in order to do that, we're going to have to leverage digital technology in a way that we haven't done before. This was already trending as we went into this crisis, but this crisis is precipitating a need for all of us to invest more time and energy in figuring out the digital solutions that can allow us to bring access to finance and financial services to women at scale and cheaply. And as we do that, one of the things that we feel we all need to be particularly mindful of is the financial consumer protection risks that are associated with this increased access to finance. And part of what a sound framework for individual insolvency will do is to help mitigate the risks that increased and perhaps unfettered access to finance might bring. So we see these two topics, and they have always been symbiotic and two sides of the same coin, I suppose, and working very closely together. And so we really want to commend and thank our friends and partners at UNCITRAL for organizing today's event and for putting these two topics together so that we can have a comprehensive conversation on what the entire framework for insolvency and secure transactions looks like. And I want to leave you in the very capable hands of the two excellent moderators that we have for these sessions. In the insolvency session, you're going to be moderated by Antonia Menezes, who is a colleague of mine and is a senior financial sector specialist based in Washington, D.C. She's practiced internationally in both common and civil law jurisdictions at leading international law firms, has assisted more than 40 countries in reforming and strengthening their insolvency and access to finance regimes. She represents the World Bank Group in Working Group 5 at UNCITRAL and is a fellow of Insol International, and also brings a background in international arbitration that informs a lot of her work with governments. And of course, the second session will be moderated by Professor Louise Gullifer, who is a professor of English law at the University of Cambridge. She's also an associate member of 3VB, where she's practiced for a number of years, and a venture at Gray's Inn. And Louise, as you all know, teaches and writes extensively in all areas of commercial and financial law, particularly around financial collateral and secure transactions, and has acted as an expert witness in many cases over the years concerning set-off, intermediated securities, and insolvency law. So it's wonderful to have both Professor Gulliver and Antonia here today to moderate these two sessions. I want to leave you with, again, a Big thanks to our friends and partners at UNCITRAL. Welcome to all of you, and I will turn you over to Antonia.
Thanks, Mahesh. Good morning, good afternoon, everyone. Thank you for joining our panel in which we will be discussing targeting micro, small, and medium enterprises from an insolvency perspective. I've been asked to inform you that the question and answer function is now available, so please do send through your questions. And states who wish to intervene can request the floor also through the question and answer chat. I will give a brief introduction on MSME insolvency and particularly the work that the World Bank Group has been doing in this space before handing the discussion to my two panelists. Obviously, there is currently a lot of concern regarding MSME financial distress during the COVID-19 pandemic. Some have called it a bottom-up crisis with a heavy proportion of MSMEs being affected first. A World Bank paper from the Development Economics Vice Presidency from May 2020 estimates the mean survival time of nearly 7,000 firms in 12 countries as ranging from 8 to 19 weeks, with retail being the lowest, while on average firms have liquidity to survive between 12 and 38 weeks. These stresses will be particularly significant for small businesses. The World Bank is also collecting data on COVID-19 response measures, which show that the primary types of government support being currently given to MSMEs are first debt finance, so for example, concessional lending, followed by employment support and tax measures. Outside of the COVID context, and as Mahesh mentioned, and I think as many of you know, the World Bank and UNCITRAL are the Financial Stability Board designated standard setters in the field of insolvency and creditor debtor rights. In this context, the World Bank has developed the Principles for Effective Insolvency and Creditor Debtor Regimes, the ICR principles, advised by a task force. And this represents best practice standards for evaluating and reforming countries' insolvency regimes. Even before COVID-19, there was increasing recognition that micro and small enterprises, MSEs, form the majority of enterprises in most economies, and governments and regional trading blocs around the world started examining policies to address this very large but fragile group of economic actors. The World Bank ICR Task Force is now in the process of adopting new ICR principles that will be specific to the insolvency of micro and small enterprises. These principles aim at reducing the complexity and costs of ordinary insolvency proceedings and creating favorable conditions for debt restructuring and in particular discharge. I don't have time to go through all the standards, but just to give you an idea of what some of them are, there is recognition that the definition of MSEs differs across socio-economic contexts and jurisdictions. And so we recognize that the definition of what constitutes an MSE must be a policy decision of each state. To the extent possible, out-of-court arrangements or hybrid procedures should ideally resolve MSE financial distress at an early stage. But we also recognize that simplified reorganization and simplified liquidation proceedings should be available for both natural and juridical persons. Access to insolvency proceedings should be inexpensive and quick, and there should be fewer and simpler procedural formalities and shorter deadlines. In a simplified reorganization, we recommend that MSE management should remain in control of the business to help incentivize MSEs to apply for reorganization in a timely manner. However, we do understand that the majority of small businesses will most likely need to go through liquidation proceedings. And so we recommend that these proceedings should be simplified, and a very key feature that there should be broad open access to discharge for good faith debtors, although we agree that narrow limitations might be needed in specific circumstances to avoid abuse. And critically, we see a strong tailored institutional framework as crucial to having an effective MSE insolvency regime in place. In fact, a lot of our technical assistance work currently is helping countries put these institutions in place for MSEs. So we anticipate these principles will be published in the next month or so, and they will be available on our website. So against this backdrop, let me briefly introduce the two panelists. Jason Kilbourne is a professor of law at UIC John Marshall Law School, the University of Illinois at Chicago. He teaches bankruptcy, commercial and business law, and civil procedure, and has provided extensive assistance to the World Bank Group in its work related to MSME insolvency and natural person bankruptcy. Kathleen Burke is a board member of the International Women's Insolvency and Restructuring Confederation, IWORC, the London chapter, and also represents the IWORC delegation at UNCITRAL's Working Group 5. She is a corporate restructuring lawyer and is qualified to practice in England and Wales, California, and New York. So to get started, I think it would be useful to discuss further why MSME insolvency regimes are needed. And Jason, I was wondering if you could perhaps start off by telling us what is the purpose of insolvency law in an MSME context? Why do we need specialized regimes? And how is this expressed in practice today in different jurisdictions?
Yes, thank you so much, Antonia, and thanks for everyone for being here. This is such a thrill. A major global issue that we see around the world and have for many years is applying a big business approach to small business, to MSEs, which have a very, very different situation, particularly with respect to leverage. The paradigm of saving big business is saving the entire enterprise. That is a collection of assets deployed in a particular way to achieve a particular approach to business. The MSE context, alternatively, is primarily about saving individual entrepreneurs. We're trying to reinvigorate their energy, maybe pursuing the business that they had been pursuing before, but perhaps not. But it's the individual who takes center stage here rather than the large deployment of large assets. Another difference is the perception that creditors are masters of their own fate and that creditors should be entirely in control of an MSE restructuring. That approach works well in the context of a large limited liability entity. It works less well in the context of a very small entity, which is principally governed by an individual. We really need in that context an alternative to offer relief when it's necessary, and an alternative to leverage the plan negotiation process. That alternative is an official administrator prepared to preserve societal benefits by conferring relief without creditor consent. There's a common emphasis around the world on facilitating creditor negotiated workout plans, which is great, and sometimes that paradigm works well in the MSE context as well. Many factors, though, practically undermine the successful achievement of that approach in the MSE context, principally as a function of the much lower income and asset values available in the MSE context. First of all, most small businesses have rather poor advisory support. Even if they have advisors, their advisors are not the sorts of fancy large law firm and business accounting firm representatives who we see representing the large companies of the world, who are able then practically effectively to engage with their creditors. And the individual business people themselves tend to have much lower sophistication. They have a lot of energy and they have entrepreneurial spirit, which we want to encourage, but they don't have the sophistication to be developing pitches to a group of creditors to sort of work things out in the way that we often read about in the financial press. Maybe more importantly here is a significantly depressed level of creditor engagement. There's just simply too little on the line here to offer a proper incentive to creditors to engage in this process. Creditors don't really see what's in it for me. The losses from writing off the debt of a small business are, in many creditors' books, barely a rounding error, as opposed to the extremely large reorganizations that we see that succeed primarily because creditors see that they have a particular incentive to negotiate in that context. Otherwise, they themselves face very significant losses. The incentive situation in the MSE context then is very different. Rather than simply pursuing collection, there doesn't seem to be a significant upside for creditors to engage in that process. And moreover, in the small business context, the stakes are very personal. Individuals have borrowed very often from other individuals. This is not simply a business negotiation, it is intensely personal. These people have failed to honor their personal bonds, which changes the negotiating dynamic dramatically. Unlike in corporate bankruptcy cases, therefore, MSE bankruptcy is largely not a platform for negotiating payment plans. It does happen, but it's not really its principal function, and its principal function is not about debt collection, benefiting creditors. There's very often very little value available there. It's about rescuing the individual entrepreneur to reinvigorate that person to confer benefits on larger society, the benefits that we derive from that person being active. This is a hospital, not a prison, and not a boardroom for negotiating deals. These people, small business people, need a fresh start to get them being active and productive again, because people who can't enjoy the fruits of their labors are going to very likely stop. They won't see what's in it for them. They will become inactive, and we need them as a world society to get up and keep going. We rely for our own success on their ambition. What's needed here then is reducing the creditor-oriented expenses and complexity of plan negotiation on the one hand, but perhaps again more importantly, introducing the leverage of an alternative, a plan B, a standard forced compromise leading to a law-imposed discharge, that is to say, forgiveness of unpaid debt. We see these two approaches levering off of each other in the main legislative initiatives on this score around the world over the past about 10 or 20 years in Asia, in Europe, and obviously in my home country, the United States. The U.S. Small Business Reorganization Act, effective in February of this year, responds directly, not only to the needs of small businesses, but also in small part to the COVID crisis that we're now facing. First of all, it supports more negotiated plans to rescue what's identified as small business. And bear in mind, when we talk about small business here, we mean, to begin with, $2.75 million in total debt. That number was raised to $7.5 million in total debt as of March for the next year. These are quite large businesses by most people's standards, but they still count as small business in this context. For those kinds of businesses, quite large but still small enough that we can't effectively engage creditors in negotiation, we need to reduce complexity and add support by removing creditors' committees, by eliminating the disclosure statement, a complex description of the company's business and its future, by introducing support for small business people in the form of some sort of advisor, and increasing timelines, making sure that plans are proposed within 90 days to reduce expenses of professionals. Unfortunately, though, for the reasons that I mentioned a moment ago, even these changes are unlikely to be successful in the context of a small business. We need an alternative, a plan B, to lever creditors into agreeing to a plan in that plan A context. That is to say, if the small business person is able and willing to offer the following standard compromise, the court will simply impose this on creditors. This compromise is the small business offers projected disposable income for 3 to 5 years. That's what we expect of people. Do what you can. Use all of your income that's available beyond standard personal and business expenses. If you offer that to creditors, we will allow you to stay in control of your business. No creditor turned over, no control turned over to creditors, and we won't ask them. We'll simply, as a legislative policy matter, decide that is what we expect of small business people. The end result in the US and many European and Asian countries then is a law-imposed discharge of unpaid debt. Once again, the principal purpose of which is to get that entrepreneur going again, maybe in the existing business, maybe a new one. The challenge, and we appreciate this, the challenge is finding a proper institutional check to see that debtors are actually offering their best disposable income and acting honestly, and we'll discuss that shortly.
Thanks very much, Jason. I particularly liked your analogy to a hospital and not a prison, with which we very much agree. Kat, as I stated in the introduction, I work as an observer organization at UNCITRAL's Working Group 5. And as we know, this working group has been discussing a draft text on simplified insolvency regimes. Could you give us a summary of the draft text and in particular the key recommendations? And could you also explain how these provisions complement what is already found in other UNCITRAL instruments, such as the UNCITRAL Legislative Guide on Insolvency Law?
Sure, and thank you for having me here. Good morning, good afternoon, good evening for everyone. The legislative guide on insolvency is a very thoughtful guide on insolvency recommendations. One thing that is missing, and that quite frankly many of us have known to be missing, is guidance for MSEs. And the work on this has started long before the COVID crisis hit. The working group has been working on this for a few years now and is very close to having final draft recommendations. You'll find that in working paper 170, and it provides a fulsome set of recommendations for implementing a restructuring and insolvency regime for MSEs. The important thing to note is that insolvency regimes is not a one-size-fits-all, and you heard from Jason Kilburn that it's really important to get it right. There are very specific issues relating to MSEs that make restructuring in a regular regime cumbersome or unnecessarily complicated, and in some ways are just different. So some of the aspects of a regular regime that break down on the micro level, and we must remember that the goal is to provide a fresh start for struggling entrepreneurs that have failed through no fault of their own. The key features that we have in our recommendations are to focus on helping small businesses take action before it's too late. We really want to build an encouragement in the system to get out of court assistance and to explore restructuring at an earlier rather than a later stage where a full liquidation is almost guaranteed. There are personal guarantees, liens on tools of the trade, liens on personal assets, and personal insolvencies that coincide with a restructuring of an MSE that you don't see in larger business reorganizations. Many times, these insolvencies, which again happen through no fault of the entrepreneur, can have a devastating effect on the individual. We have to ensure that there are safeguards to allow these individuals to become productive again and to contribute to society. We also want to make sure there are consolidated procedures for personal insolvency where appropriate, so that it's not a series of insolvency proceedings for the individual and their family. There's a cost aspect to it, and the goal of the modified regime is to reduce costs associated with the restructuring. And that can be done by reducing the procedural aspects, which I'll come to in a minute. But also, we need to be aware of the fact that a lot of times, as Professor Kilburn mentioned, these are zero asset cases. And there needs to be provision to help these cases get through the system where the funding cannot come from the estate. So reduced formalities are incredibly important. The logistics of navigating through an insolvency for small businesses should not be a logistical nightmare. They need to get the relief they need quickly when they qualify for the relief. Once they qualify, the logistics should be limited so that these entrepreneurs can focus on what's really important, which is their businesses, and steering them through the restructuring to come out stronger on the other side. The recommendations set out many areas where these formalities can be minimized and where hearings can be reduced or eliminated so that the case can move through the system quickly. And if it's a complex case that needs more time and more attention, that can be handled and it can be converted to a full restructuring case. The other issue, as Antonia mentioned, was the debtor in possession model. The simplified insolvency regime should specify that the debtor continues to operate the business in most cases. These businesses are so tied up with the individual that it may be impossible to separate the two. And there's been much debate on how that can be assisted, but we have recommended that a competent authority be put in place so that they can help drive the insolvency process. But at a minimum, the competent authority should clearly specify rights and obligations of the debtor in areas of disposal of assets, in post-commencement finance, and treatment of contracts. There's also a very specific set out of where a total displacement or limited displacement of the debtor should occur. And in most cases, that will be where there's a suspicion of fraud or abuse. But in the large majority of the cases, we believe that the debtor should remain in possession. There's also an aspect for deemed approval and the need for speed. There should be a set of rebuttable presumptions or deemed approvals where, for example, the case will proceed to a restructuring unless there will be no need for initial hearing, unless a discharge will be granted, unless certain things come into play in the restructuring that would provide for not going through these deemed approvals or rebuttable presumptions. And finally, of course, there need to be checks and balances to ensure that a debtor does qualify and is not abusing the system. Most importantly, the criteria set out for eligibility should be clear and should be appropriately balanced to ensure that these small businesses get the relief that they need. You also don't want to run the risk of creating a regime that has unintended consequences, of making it unattractive to lend to these individuals in the first place. And so you need to keep that in mind when you're designing the regime, that you keep it appropriately balanced. And finally, the checks need to be proportionate. For example, where recommendations specify shortened periods, there should be adequate time for creditors to respond. And if there are objections to certain relief, those objections should be heard. But the reality is that many times there just isn't the type of creditor engagement that you see in large restructurings. So the debtor shouldn't be penalized for a lack of participation with unnecessary long waiting periods or the impossible task of encouraging creditor involvement in these cases. Now, how do these fit in with the guide? There's been some debate in the working group as to whether or not this should be a standalone paper or whether there should be references, but in whatever form the recommendations take, they are intended to complement the legislative guide. There may be references to avoid to the guide to avoid duplication, or we may just include some of that duplication. But the important thing is you shouldn't look only to adopting one or the other. Both are needed. And the reason for this is that there were some things that are disproportionately affect MSEs that did not play a big role in larger company failures. And so they didn't receive much attention in the original guide. And these issues are simplified liquidation, as Antonia had mentioned, and the need for a full and quick discharge. The MSE recommendations layer on top of the level of complexity needed for MSEs, and they build on the guidance in the guide. So you really need to read the two together.
Thanks, Kat. That was a very comprehensive overview of Working Group 5's work. Jason, if I could hand it back to you, something that we here, the World Bank, and the work that we're doing is that MSE insolvency regimes prioritize the debtor to the detriment of creditors' rights, or that the debtor is likely to abuse the system. How would you respond to that, and how are jurisdictions currently addressing this concern of balance?
Let me just make 3 points in response to that question. First, and I think most importantly, the idea of pitting creditors against debtors and viewing this situation in sort of a bilateral way like that is a false dichotomy. Everyone in the business context at some point in the supply chain is both a debtor and a creditor. And more importantly, the real beneficiary of the kinds of relief systems that we're talking about here is not individual debtors who are somehow getting away with something, it's greater society. We all will benefit from the maximum deployment of these debtors and small businesses' future productive energy. This doesn't ignore creditors. It's a recovery compromise that we expect of them as responsible participants in our business society. We offer them the value that's reasonably available now, but we impose relief to foster future value production for all of our benefits. This compromise, by the way, is especially appropriate in an era of pandemic, right? Both literal and figurative, financial and biological now, hugely higher numbers of small businesses are going to be seeking relief. The vast majority of these people have done nothing wrong, as we've heard already. They've taken risks. They've benefited society. We need to encourage that risk-taking behavior, more innovation, more production for, again, all of our benefits. Second, Choosing an appropriate institution, as I suggested before, is absolutely crucial here. Some states have dedicated bankruptcy courts or commissions to assess plans and the debtor's best efforts, discharge offers. Others use different actors like collection authorities or tax authorities or ad hoc institutions of some kind. The key challenge here is funding these institutions. It's a major challenge. We're working on that. We're happy to work with people to find the right funding mechanism to have a check on abuse to the extent that people are concerned about that. But third and finally, abuse is far less frequent than most people generally perceive. We can't let a few isolated cases of shocking and noticeable abuse destroy our dedication to providing necessary relief to millions of honest small business people. Volatile, globally connected economies mean lots of real financial distress here. And creditors have ways of discovering hidden assets. If we're concerned about people hiding value, the ordinary debt collection system is the alternative. And if that wouldn't have discovered the assets, nor will an insolvency system, nor should it be expected to. And again, in the context of COVID-19, we can be more sure and confident that the tidal wave of financial distress that we're going to be seeing here is real, is not caused by debtor malfeasance, is not caused by abuse. It's a pandemic shutdown result to which we really need to responsibly respond.
Thanks, Jason. Kat, Mahesh mentioned women struggling to access credit. Could you drill down a bit more on the gender dimension to MSE insolvency, specifically in the COVID-19 context?
Right. So there's many gender aspects to the COVID crisis, but I'm going to focus simply on the intersection of MSEs and insolvency regimes. The first issue is that you have individuals who are not traditionally involved in large restructurings that will be involved in SME restructurings, and those are spouses and family members. And how could they appear in these cases? Well, in many times in the MSE case, they have personal guarantees and liens on personal assets. You have innocent spouses and family members who suddenly find themselves in foreclosure proceedings without a way to protect their beneficial ownership. They can also be thrown into their own insolvency proceedings because of the proceedings of their spouse. And so procedural coordination should be considered for spouses as well as the individual insolvency of the entrepreneur. Now, we know that traditionally entrepreneurs are male dominated, and we can expect that many of the spouses and family members to be women. And so we expect that they will be the innocent individuals appearing in these cases, and there should be a way for them to be allowed standing to appear and participate in the proceedings where they have joint legal or beneficial ownership of this property. The other dimension is childcare, and I don't think people typically think about this as a gendered aspect, but many of the women on this panel and on the listening in will know that we've all been hearing the majority of women are handling the majority of childcare during the COVID crisis. And women are more likely to step down from their work to take on these responsibilities. So how does that fit into the insolvency regime? Well, first, when you're build back better and focus on subsidizing certain industries like childcare and nurseries and elder care. This should be paramount. If you think about the damage to the economy, if all of a sudden these entities liquidated on a mass scale, which could happen, women would bear the brunt in two ways. Firstly, they are most likely to take on the childcare when childcare options fail. And secondly, these industries are heavily dominated by women, so you will have a higher increase of unemployed women. Now, a specialized regime could provide for even more protections and, for example, fast tracking these types of cases that involve childcare companies and nurseries and elder care. They could also provide additional support for the industry to prevent them from filing in the first place. And so while that's not an insolvency regime solution, it is something to keep in mind.
Thanks, Kat. That definitely resonates with me. I think we're almost out of time. So maybe if I could ask each of you to specify that if there's one key takeaway that participants should have from this panel, what do you think it should be? So over to Jason first. What would your key takeaway of this panel be?
I would leave you again with my image that MSE insolvency is a hospital. It is not principally a business negotiation, and it certainly is not a prison. Discharge is the key here, offering plan negotiation leverage and a last resort means of extending relief and recovery and rehabilitation to small business people for the benefit of all of society.
Thanks, Jason. Kat?
Build back better. You have the opportunity to tailor the response to the particular need that COVID-19 has created, which could be a potential tsunami of MSE filings. A one-size-fits-all system that punishes small businesses or makes it impossible for them to reorganize is not fit for purpose. Consider these recommendations carefully and consider the gender aspect of supporting certain childcare and elder care facilities so that your core productive economic groups can get back to business and continue to be productive members of society. Build into your system specialized relief to help this industry as a vital first step, and then look to other important sectors of your economy.
Thanks, Kat. I'd like to thank both of my panelists, Jason Kilbourne and Kathleen Burke. I think you agree that particularly in light of COVID-19, the issue of insolvency of micro and small enterprises in particular is critical at this time. And so I hope that you found this panel helpful and useful and very timely. I'd like to now hand it over to Louise to go through the second panel. Thank you very much.
Thank you very much indeed, Antonia. I hope everyone can hear me.
Yes, we can.
Thank you very much indeed. Okay, well, good morning, good afternoon, good evening, everybody, wherever you are in the world. I am really delighted to be here to moderate this panel on the vitally important subject of access to credit for MSMEs during and after the COVID-19 pandemic. A lot of what we will talk about will be focusing on the smaller end of the MSME spectrum. And I know from my own work on the financing of micro enterprises, and also we will hear this today, that access to credit for micro and small businesses in many parts of the world was actually a serious problem even before the pandemic. Much work had already been done to improve this situation, but there was still a long way to go. Now, COVID-19 has, of course, made things worse in many, many ways, and particularly, as we're going to talk about, in terms of access to credit for MSMEs, because this is needed to help them overcome the effects of the pandemic and the difficulties that we've already heard that they are suffering from at the moment. So what this panel will do was look at the steps that are being taken by both the public and private sectors, and also how these steps will change the position going forward. What I'm going to do is to introduce each speaker as they speak, rather than just at the beginning. We've got 3 speakers. They're all extremely knowledgeable in this area, but I'm just an academic. These people are actually involved in working in countries around the world to increase access to credit to MSMEs by law reform, by capacity building, and by working and building and developing credit markets. So they'll be able to tell us what's actually going on around the world as a result of COVID-19 in this space. And then at the end of their presentations, I will draw out some themes and add some links to the UNCITRAL instruments and the work that is particularly important in this area. If I could remind participants, please could they questions they have in the Q&A function, as Antonio explained, and if any state delegations would like to speak, please could they indicate this in the Q&A function and give their name and their country. So I will now like to introduce our first speaker, who is John Wilson. He is a senior financial sector specialist in finance competitiveness and innovative global practice at the IFC and the World Bank Group. So John has been working for many, many years on secure transactions reform and the development of asset-based lending products and practices. And he works primarily in the Latin America region and the Caribbean. Before he worked at the World Bank, he worked at UNIDROIT and at the Organization of American States. So he's been working for a very long time in this secure transaction space. So I'd now like to hand over to John, who's going to tell us his views on how what's being done to increase access to credit in these very difficult times.
Thank you very much, Louise. I hope everybody can hear me.
Yes, we can.
Great, thank you so much. Well, good day, everyone, whichever part of the world you happen to be in. It is a pleasure and an honor, obviously, to be participating in this session on secure transactions and solvency reform aspects, in particular, as related to the increase of access to finance and protection of MSMEs during this COVID emergency response period. As Louise mentioned, I am one of the several global specialists within the World Bank Group and IFC that works on secure transactions reform across the globe. That we do currently have a portfolio of 56 active countries that are undertaking some secure transactions reform or aspect of asset-based lending reform. We won't have time, obviously, to go into any detail on the country level work or the global knowledge management tools, but you're welcome, if you're interested, to visit the World Bank's credit infrastructure website, which contains a lot of the knowledge guides for the implementation of secure transactions reform at the local level, and includes a lot of knowledge management guide, including our secure transactions guide and secure transactions toolkit. Obviously, this work is based intimately with the developments of secure transactions reform and development of the international standards at UNCITRAL. The World Bank Group has participated as an observer in the development of these international standards within the context of Working Group 6, and they are the guiding force of the work that we do in implementation at the country level. What I will spend the next few minutes to at least try to go into a bit of detail on the work that's being done within the public sector, private sector, and in joint hybrid work for access to finance, and in particular, the usage of secure transactions as a way to respond to the credit needs of SMEs during this crucial period, and in particular, to mend those supply chains with SME suppliers that have been affected during the crisis, and in a longer term, to try to create and shore up a lot of these supply chains that have been affected in the development of credit products and other reforms in the medium and longer term. I do have 3 slides. I promise only 3. I will try to see if I can actually share my screen. So if you can see that, I think I'm sharing it now. Yes, okay, it looks like it's fine. I will defer to the next speaker, Marek Dubovec, who will actually go into a lot more detail, at least with regard to the public sector response in this crisis. But I did want to mention just a few things because it's tied to secure transactions reform and how jointly we can work with the public and private sector to reach a greater number of MSMEs during this crisis period. So from the public sector, obviously it will come to know a surprise to anyone, and Hash Uttam Chandani had mentioned the work that the World Bank is actually doing in direct funding to states, and the work that states are doing in direct funding to the MSME sector. Obviously, the funding from the World Bank Group itself, as Mahesh had mentioned, takes place mostly through these development policy loans that are directed for COVID response. And at the state level, this then becomes a second tier type funding where a government agency or development bank ends up providing funding to direct lenders who have a SME outreach or portfolio of lending based on the funding that they received at that level. A second and significantly important with regard to secure transactions aspect of a lot of state interventions are the types of credit enhancements that many public sector entities have provided, including partial credit and reciprocal guarantees and credit insurance. From our standpoint as well, borrower subsidies have played a significant role, and in particular, I'll mention this when I get to the sort of the hybrid response in terms of the grace periods or extension in payment terms that have been allotted to MSMEs during this, especially this initial period of crisis response. We are seeing that a lot of those grace periods are starting to either become extended or expire. There are needs for either new access to finance, the refinancing of those loans that were previously covered by these grace periods, or the creation of other types of tools to deal with those MSMEs that still don't have the opportunity to become current on those loans. Sector targeting, obviously, this is an important dimension. The issue of women entrepreneurs has been brought up, but I think that we know some of the sectors that have been particularly impacted by the COVID crisis, and obviously this is an opportunity for the states to really direct a lot of their aid to that. Finally, technology and legal infrastructure, these go together in terms of like the work that UNCITRAL has done and the World Bank has done in to try to improve the access to finance through the development of technological infrastructure and legal infrastructure. So from the private sector standpoint, for those states that have actually undertaken secure transactions reform, one of the advantages is that through the International Finance Corporation and in providing either direct lending, not to the public sector or not to governments, but to the private sector itself, to banks and to other non-bank financial institutions that have a reach for SMEs or that currently have a portfolio, in those states that actually have secure transactions reform, it allows us to work with the states. And this is just one example where we've been working with different states, with different banks in those states that have reformed their secure transaction systems in developing new asset-based lending products based on those reforms. And this has been a two-stage sort of or two-phase methodology. In the first phase, where we're talking about the mending of supply chains that have been affected. And in the second phase, where we're talking about the development of a longer term strategy for the usage of secure transactions reform and asset-based lending tools with private sector entities, primarily with banks. And then obviously the usage of public sector and private sector funding or programs, when they're used in conjunction, will help us reach a greater number of SMEs that are affected during this crisis. And in particular, we just have one example here of one of the products that can be developed in those states that have a secure transactions reform based on the UNCITRAL model law. And there are several states, obviously, with which we are currently working to reach that standard, but there's obviously a lot of states that already have it. And in working with the private sector, we can develop a tool, for example, merchant cash advances or secured merchant cash advances, where you're taking a security interest, as just one example, in credit card receivables. And by taking the work that's being done with the private sector, and the financial institution to develop this product and to launch this product for SMEs, and combining that with the work that and the stimulus packages and other development bank or state development packages, then we can reach a greater number of SMEs, and this is an important aspect from that standpoint. So let me stop there and turn it over back to Louise.
Thank you very much, John, and thank you for sticking to time so well. That was incredibly interesting. We're now going to move on to Marek Dubowec, who is the Executive Director of the Koszalczyk National Law Center in Arizona. Marek I know very well. We first met in UNCITRAL Working Group 6, and we've done a lot of work together. Marek's been involved in access to credit reform projects pretty much all over the world: Africa, Asia, Eastern Europe, Middle East, and Latin America. And he's written very extensively on all of this. He and I have last year published a book together on secure transactions systems and reform in Africa. He's done a great deal of work as well with the World Bank and developing substantive content both on secure transactions and very recently on the potential of DLT, distributed ledger technology, within that context. So Marek, perhaps I can hand over to you now.
Thank you, Louise, and hello, everyone. Thanks also to the organizers. It's my pleasure to be here with everyone, and also thanks for the background that was provided during the earlier session on insolvency, as well as the background that Mahesh provided, which is extremely useful and highlights the types of issues that both of these products and areas of the law look at, which obviously challenges the current crisis, challenges the potency of secure transactions in facilitating a recovery. Just to put this panel into the perspective for some of those who might not be familiar with secure transactions, I've read a statistic that the volume or amount of receivables, which is a typical asset of an MSME, essentially equals the volume of corporate bonds that have been issued. So there are all kinds of public measures from central banks that facilitate that type of financing at the highest level. But as we can see from the statistics, there is a great need to facilitate financing at the bottom level, since most of SMEs have those kinds of assets, which the high level programs do not target. My underlying theme of the presentation is coordination of private law measures with any public fiscal, monetary, and regulatory measures that John touched on in his remarks earlier to facilitate recovery, because I believe that the two need to be coordinated and go together well in order to facilitate this type of recovery, and I will provide some specific examples on that. So to start out, I wanted to just provide a brief overview of the types of financial institutions that play a role in this process. Obviously, commercial banks, but also John mentioned development and state-owned banks that many emerging economies have and established for specific purposes. And those purposes are now being enhanced to facilitate recovery. Obviously, Mahesh also mentioned the World Bank Group itself. There are other institutional lenders that provide financing in this space. And since I mentioned the central bank, just one specific example of how MSMEs may benefit. Even though the central banks provide programs at the top level, often the beneficiaries of those programs, such as large corporations in the European Union that benefit from the ECB program, extend more credit to their counterparties. So a large corporation that works with a small supplier would not request to be paid 30 days after delivery of goods, but instead would extend the payment terms. So some of these programs essentially trickle down, and the beneficiaries, even though the direct beneficiaries are large corporations, we see some benefits also for those who operate in supply chains that are small and medium-sized businesses. Now, as for some of the specific measures that have been taken, I have categorized them into three brackets. One would be the private law measures. The other one would be just public measures. And then some regulatory measures that concern capital requirements. And I don't want to go into too much detail, but all of those to some extent affect access to credit, in addition to restructuring of the loans and reorganization insolvency, as was very nicely explained earlier. There are all kinds of other private measures taken. For instance, utility payments have been deferred, which often raises a question of priorities as against the claims of secured creditors. The pandemic also challenges some of the established rules of secure transactions framework, such as for lenders acting in a commercially reasonable manner and in good faith. What was commercially reasonable and in good faith pre-COVID may not be commercially reasonable and good faith during the present times. As for some public non-regulatory measures, we all know that there are all kinds of loans given out by governments that may be even forgivable, all kinds of measures to support export credit agencies and credit insurers, all kinds of moratoria on enforcement, and most significantly, which I will come back to in a minute, are public guarantees. The OECD identified public guarantees as one of the two primary tools to facilitate access to credit with secure transactions. And during the current crisis, that is the tool that has been ramped up. In other words, many states already provided public guarantee schemes, such as Japan and Korea, where the loans that are guaranteed amount to 7% of their GDPs, and these programs have been ramped up. As for some of the regulatory measures, this is an aspect that obviously UNCITRAL looked at as part of its practice guide, and this is part of World Bank reforms and reforms of other institutional lenders, because there must be also some incentives for financial institutions to extend this kind of credit, and at times we find that regulation may skew the incentives of the lenders. So some of those measures have been taken on this front, such as lowering capital requirements for SME loans and facilitating provisioning for defaulted facilities, which obviously becomes quite complicated these days. And some specific measures have been taken by the Basel Committee, that is the primary regulator or international standard setter in this space, to also facilitate restructuring, for instance, of non-performing loans. However, some of the issues are quite challenging for the legal framework to address. For instance, what is good collateral these days? We had challenges identifying good collateral before the crisis, as there was reluctance to lend. Today, secondary markets do not operate at all, which makes it almost impossible for lenders to value the collateral and to have the confidence that the collateral may be disposed of. And as we know, the values of collateral have significantly gone down during the crisis, as a result of which over-collateralization becomes quite important. The other issue, which I mentioned earlier, are public guarantees. And I just wanted to highlight in that context that numerous studies done by the IMF and the OECD identified deleterious effects of public guarantees on lending. Yes, everyone gets their credit at a low cost. However, the qualitative effects are somewhat negative in the context, channeling funds to unproductive borrowers, or prolonging the existence of companies that should be liquidated. So some of those aspects obviously would need to be looked at in the broader context. And finally, what I see as a transition to the new normal, actually, during, as you may recall, Luis, during our prep call, Mary Ellen's colleague quite rightly pointed out, we don't want a return to the normal. We want an improved normal. So in that context, I see a great role for secure transactions, legal regimes, not only in the primary market when an MSME gets a loan, but also in the secondary market. What do we do, or what do banks do with those loans that are secured with a collateral? Do they just collect, restructure those debts, or do they repackage those loans and resell them in the secondary market, for instance? In the past, many facilities, even in the United States in the 1960s, were established by Federal Reserve banks to facilitate agricultural financing. States like, for instance, Mexico established receivables exchanges to facilitate the trading of receivables. Obviously, all of these secondary markets also require a particular legal regime for those transactions, where receivable is sold or a loan packaged with warehouse receipt is resold. So I see a greater role of secure transactions in cleaning up the market of NPLs. And then finally, just a brief word about blockchain. Obviously, there's many developments in this area. Just last week, for instance, the Bank of Japan announced that they would look into the central bank digital currencies. And what's interesting in that, in the context of the announcement, is that the program cited, or the announcement cited, financial stability as one of the objectives for the issuance of CBDC during the pandemic itself. So I see that there are also some promises in that space that could facilitate recovery. Thank you very much.
Thank you very much indeed, Marek, and lots of food for thought there. Our next, we will now move on to consider a theme that has already been mentioned in the last panel and by Mahesh, which is the position of women in the pandemic. And we have as our speaker, Mary Ellen Iskenderian, who is President and CEO of the Women's World Banking. Women's World Banking is a global non-profit organization devoted to giving low-income women in the developing world access to the financial tools and resources they require to achieve security and prosperity. And Mary Ellen is a passionate advocate for women's economic empowerment through greater access to finance. She has worked in the private sector, worked for Lehman's, she's worked at the IFC as well, but now she's going to talk to us about the access for finance for women and how the pandemic has affected that. Thank you, Mary Ellen.
Thanks so much, Louise, for that kind introduction. And as many of the other panelists have said, it's really a great honor to be with you today. I think, Jay, are you handling my slides? Great. You can go to the first slide. We spent a lot of time this morning my time, I'm in the United States, East Coast, talking about this mythical MSME. So I just thought I might put it in a bit of context in terms of, yes, these are the most hard hit companies by the pandemic crisis, but why they are going to be so critical to the return to growth and to recovery. Just looking at the really enormous size of that they contribute to the economy and to job creation. But I must say, in listening to the earlier panel, I was brought back to my very earliest days joining into the world of development finance, where I was told the most important lesson to remember is that capital won't flow into a market if it doesn't think it can get back out again. And so I think while the first panel focused so eloquently and fascinatingly on insolvency and workout situations, let's just remember that it's still extraordinarily difficult for these companies to really get access to finance, and we still see a $5 trillion financing gap in developing countries. And I should underscore that this refers specifically to formal registered MSMEs. Could you turn to the next slide, Jay? Thank you. So this gives you a little bit of more of a breakdown of who's amongst those companies. And we see that really at every level, at every geography, women are much more disadvantaged in getting into the market. And while we often think of women micro entrepreneurs, very small, informal, primarily cash-based businesses, often out of the home, again, I'm referring to here specifically formal registered businesses where we see, or at least prior to the pandemic, we saw women entrepreneurs starting businesses at a much faster rate than their male counterparts. And I think very importantly, as we think about recovery, as we think about that Build Back Better and women's labor force participation, women-owned businesses hire other women at a much greater rate than do men. Perhaps if we move to the next slide, I can say a little bit about what we see as some of the principal barriers to women's access to credit, and why I think that this conversation here with this group of people thinking about secure transactions, thinking about the access to credit issues as they relate to insolvency issues is so important. So never underestimate the fact that women across the board in the developing world have much less access to formal legal identification. And as more and more government services, as more and more financial services, more and more services of all kinds are moving onto digital platforms, the lack of a digital ID, even or the gap between men's and women's digital ID is even greater. And indeed, women's access to digital technology, when it comes to smartphone access, so feature phone access, that gap is slowly closing, but we do see a considerable gap in terms of smartphone access. And so the issue of formal identification is one that so many of the solutions and issues that have already been discussed this morning just will not be able to find the women and their businesses without that identification. But then, as we've also talked about in terms of physical collateral versus other types of collateral, there are still far too many countries where women have unequal land ownership rights, where even under marital property regimes, the husband will still have the right to dispose of property without the wife's prior knowledge, including not only marital assets, but assets that the wife may have brought into the marriage. So there's still an enormous amount of work remaining to be done on women's property rights and women's and the treatment of women in terms of property. Many countries, though, have made some real strides in opening up titling opportunities, where even if a woman does not necessarily have does not bring a piece of property into a marriage, if her name is placed on the title, that might be a piece of property that can be used for securing a debt that her company might want to take out. But I think it's important for this audience to look at some of the very critical credit infrastructure gaps that exist. Again, collateral restrictions that don't. If you could just let me finish on that last slide, Jay. I'll that previous slide. Nope. Backwards. Sorry. I'll just finish up quickly on the collateral restrictions that really only allow physical collateral in still so many countries. The introduction of movable collateral registries, secure transactions laws that take financial assets into consideration in terms of collateral have had tremendous impact on women's access to finance. Very often women are in service-related businesses that don't have those physical assets, but they do have, as some of the previous speakers alluded to, they would have accounts receivables that could be used to provide security against a loan. We see in far too many countries credit sharing mechanisms are very limited, and they're specifically limited to the kinds of reputational collateral that women may have more so than men. Many credit bureau and credit sharing regimes don't accept information on utility payments or retail payments. And in far too many countries, a woman entrepreneur may have built an excellent credit repayment history through the microfinance system, but then that information is not then transferred to the wider credit sharing regime when she tries to take a loan from a bank. And then we'll talk in a moment about some of the asset-backed lending options with fewer physical assets in her name. A woman can really benefit from asset-backed lending possibilities that either allow her to finance off of the piece of equipment that she's trying to buy, or through other receivables or invoice-related mechanisms. And then one important point, and it's one that I'm always kind of resistant to raise, but it unfortunately keeps rearing its ugly head, and that is just outright gender discrimination. And we see in far too many countries, and there's a growing body of really excellent research that does show that at least when a woman borrower is paired with a male loan officer, you will see, at least for her first few loans, higher interest rates, smaller tenors. Women are much more likely, and thinking back to Kathleen's point about guarantors, much more likely to be asked to bring a guarantor or to provide a personal guarantee, even with the same financial profile as a male borrower might have. So just flipping to that next slide, then Jay, I wanted to just say a brief word about the 51 financial service providers throughout the developing world that Women's World Banking works with, and we've been staying in very, very close touch with them throughout the crisis, trying to hear about what their approach to these companies will be throughout the crisis and then coming out. And while they've raised many concerns, we see one very exciting opportunity that Mahesh mentioned at the very start of our time together, which was the opportunity for digital. Those organizations that have already digitized some element of their operations are seeing ways to stay in touch with their clients. We're seeing some fascinating technologies. You've seen interactive voice response mechanisms being employed, SMS messages being used. So digital is going to be the future, and I think is going to be an important part of the recovery. And if we could just go to my last slide, I wanted to talk about three quick opportunities specifically related to digital. The first is, we've been seeing a pre-COVID trend that we're only going to see increase as more women entrepreneurs bring their business onto e-commerce platforms. It's sort of the best of all worlds for a woman entrepreneur, since so many of those businesses start as home-based businesses, so they can stay in that more local milieu, but they can reach a much broader audience. We're seeing literally throughout Southeast Asia, South Asia, Latin America, so many businesses really basically getting their start, booking orders, their marketing, staying in touch with clients through WhatsApp. So we're seeing a real movement for women entrepreneurs onto digital platform. The second is really the enormous opportunity we've seen through the COVID crisis of nearly every country around the world has either introduced or adapted a G2P payment to COVID response. And fascinatingly, a lot of the barriers that we had previously seen, whether it be from FATF to other KYC requirements from other standards and central banks and countries, we've seen those start to fall as more and more accounts are opened. And if it's a digital COVID response payment, then you're automatically seeing those recipients coming onto digital platforms. And we just think this is a group of newly financially included people, including many entrepreneurs, that we would hate to see that opportunity lost. And in fact, we've even been talking to sub-governments, including the government of Indonesia, the subject of the report that's focused here, that as they think about trying to graduate people from their G2P program, perhaps allowing that payment to be used as security or collateral, or going towards a bank loan that might get that business that to last stage. And then very quickly, lastly, I'm very excited. Marek mentioned the possibilities for blockchain. We're seeing fintechs that had good ideas, good digital ideas around the credit infrastructure, particularly in asset-based finance, really starting to come to the fore. One company that we like a great deal is a Nigerian sort of online factoring company called Lydia that sort of acts as a broker between large, fast-moving consumer goods companies, other larger, well-known companies, and smaller companies in their supply chain, discounting receivables as a traditional factor would and providing loans, but all done online, all done digitally. And so we think in that spirit of building back better, that some of these fintech solutions that were good ideas before COVID are going to be part of the solution post-COVID. Thank you very much.
Thank you very much indeed, Mary Ellen. That's really, really interesting. And I'd like to thank all our speakers for their very insightful, thought-provoking presentations. Very quickly, because I know we haven't got much time, I'd like to draw out just a very few themes of what we've heard, and that might perhaps spark some questions. You can always leave your questions in the Q&A box. So first and foremost, it's quite clear from what we've heard, continuing need for improvement of access to MSMEs, and this has been made much more urgent by the effects of the COVID-19 pandemic. The impact, as we've heard, has been particularly serious for micro enterprises and for very small businesses, which are often run by women. And the future work of UNCITRAL in the area of access to finance for MSMEs, therefore going forward, will clearly be of the greatest importance in that area. Secondly, we've heard about the importance in this situation of secured credit and asset-based lending. We've heard about the need for capacity building, the development of new products and secondary markets. And John has also, and Marek has told us a bit about the legal infrastructure, which is an important part of this work, both in terms of how a state that has already reformed their law makes it much more possible for the IFC to develop structures and products that enable MSMEs to access to finance and financing their supply chains. And we might also perhaps hope that reform can be carried out in other jurisdictions which really need more access to credit after the pandemic, that maybe at least something can come out of the problems that have occurred towards more best practice in secure transactions law. I've been personally very involved in the UNCITRAL model law, as I'm sure many people here have. For those who don't know, the UNCITRAL model law is a best practice legal framework for secured transactions, including a robust registration system, collateral registration system. And as we heard, for example, from Mary Ellen, being able to take security over receivables is very, very important to enable women to have access to credit. The whole of the model law system is there to make lenders feel more confident, and so they will be prepared to lend more and at a cheaper price. The other instrument of UNCITRAL I would mention is the model law practice guide, because this actually focuses on the model law on the ground, how the model law can be used in practice to develop lending products, and what both lenders and borrowers need to do to take best advantage of the opportunities the model law provides. The third theme I just mentioned is that we've heard from both John and Marek that the response in relation to MSME funding, the response to the pandemic, has come from both the private and the public sector. And we might want to even think a bit more about how those two types of responses can feed into each other, and how the public response, where there are limited resources, can be leveraged by the use of private sector offerings and the use of movable assets as security. And then lastly, we've heard about the importance of digitization and technical innovation, blockchain, and also all the other products that Mary Ellen told us about. And that is clearly very, very important, and it's important that the legal infrastructure keeps up with this level of innovation, and I'm sure that's something going forward that we will be tackled by all international institutions. It also points up a divide, maybe we might want to just think about this as well, between those to whom this technology is available and those to whom it isn't, like all those women that Mary Ellen were telling us who don't have smartphones. How can we close the technological gap as well as the access to credit gap? So all in all, this panel, I think, shows clearly the importance of the future work of UNCITRAL as well as IFC and the World Bank in this area of access to credit for MSMEs, both now and in the future. And so now I'd like to give the floor to Anna, who is going to chair, I think, the state interventions, and then after that, we will have time for some questions and answers. So do add some questions and answers to the Q&A panel. Thank you.
Thank you very much, Louise, and thank you to all the speakers and moderators of the two previous sessions that have highlighted the importance of the ongoing work of Working Group 5 on MSME insolvency and the future work of Working Group 1 on access to credit for MSMEs, which is one of the many topics that the UNCITRAL Commission is going to discuss at its resumed session in September. So I think we have been heavy on the Western Hemisphere, and we are very grateful for those of you who had to wake up very early to join us in this webinar. And I think that we can now tilt the balance towards the East and give the floor to Thailand. I understand Thailand has asked for the floor.
Thank you, Madam Secretary. First of all, we would like to thank all the previous speakers for their informative presentations. On this particular topic, Thailand would like to share the following experiences. Since March this year, the Thai government have been introducing a number of economic relief measures as well as stimulus packages to inject liquidity and preserve credit for SMEs for their continued operation and to maintain employment levels. These plans have been implemented by the Ministry of Finance in conjunction with our central bank. The main measures include, first, for current SME business loans, the central bank has encouraged financial institutions to suspend debt repayment obligation for at least 6 months and reduce interest on case-by-case basis. The recommendation also include the refinancing of existing debt by allowing a longer repayment term with a lower interest rate. Secondly, a group of specialized financial institutions, including the Government Savings Bank and the Bank for Agriculture and Agricultural Cooperative, have supported loan packages and debt restructuring schemes. These packages include short-term loan with a low interest rate for the loan term of 2 years. Some emergency loan plans require no collateral or guarantee. Their aim are to support farmers, freelancers, as well as low-income individuals whose business have been affected by COVID-19, such as street vendor, taxi driver, and tour guides. The SME Development Bank has launched its lending packages with loan term of up to 7 years. The approved lending will receive supporting guarantee from the Thai Credit Guarantee Corporation, which is a state-owned enterprise. These offers are specifically for startup operation, business improvement, business expansion, and refinancing. Thirdly, the Social Security Office has extended its existing lending project for business operators to support the hiring of employees during this pandemic. Fourthly, contributions to the Social Security Fund have been lower for both employers and employees in an effort to reduce the pressure on employment. Fifthly, the Treasury Department allowed a rent moratorium and or reduction of rental fees for SME that rent state land or other state property. Concerning tax measures, there are many measures implemented to increase liquidity for business and lessen their primary tax obligation, such as the reduction of withholding tax, deduction of certain type of interest rate and salary expenses at an accelerated rate. The tax authority have also deferred their tax filing deadlines. Regarding the insolvency law, Thailand added a specific rehabilitation chapter for SME in 2016. This part provides an additional way out for SME in financial distress. SME can enter the process at an early stage of their financial difficulties. The duration of the process is shortened through the usage of a pre-packaged bankruptcy scheme. Furthermore, the debtor is allowed to remain in control of his or her business. As soon as the SME complete partial repayment of their outstanding liabilities, they will get a discharge on the remaining balance. At present, the Thai government are in the process of amending this law to accommodate more SME which are in need. At this juncture, Thailand is also focusing on the pre-insolvency period. Out-of-court debt restructuring is strongly encouraged by our central bank. The new repayment agreement should reflect the current capacity of the debtor, and the seizure of the debtor asset should be delayed. In conclusion, Madam Secretary, Thailand's main efforts involve providing quick and appropriate response to reduce the debt burden of SME, by at the same time taking into consideration the risk management of the financial institution. We hope very much that all these measures will overcome most, if not all, challenges faced by SME as a result of this pandemic. Thank you.
Thank you very much to the distinguished delegate of Thailand for sharing the experience and the best practice put in place by the government of Thailand to mitigate the effects of the COVID-19 pandemic. I am told that Japan has asked for the floor, so I give the floor now to the distinguished delegate of Japan.
Yes, thank you very much, Madam Secretary General. I hope you can hear me. I would like to introduce the system that we have in Japan to cope with this crisis in terms of access to credit. In Japan, we have two major ways to cope with this crisis. One is JFC loan. JFC stands for Japan Finance Corporation. And the other is loan with CZC. CZC stands for Credit Guarantee Corporation. So the first one, JFC loan, this is what John has mentioned as direct funding. JFC is a national development bank. It's a policy-oriented bank in Japan, wholly owned by Japanese government, catered for financing for SMEs and to respond to risks for unexpected circumstances such as natural disasters. So JFC has created a special loan to adapt to this COVID situation. And the other is loan with CZC. This is a scheme where a loan is done by commercial banks, but it is with a guarantee of Credit Guarantee Corporation, which is the public guarantee system in Japan, which Marek has mentioned in his presentation. The scheme to adapt to natural disaster or economic hardship as an industry in whole was already provided for under the law regulating CZC that gives special guarantee. So this is a result of a collapse of Lehman Brothers and the big earthquake that occurred in Japan in 2011. So COVID is considered as such incident, so this special guarantee system applies. Many MSMEs rely on one or both of these loans, so both JFC loan and loan with CZC work together. And the eligibility depends on the drop in the revenue, ranging from decline of 5% to 20% or more, depending on the type of loan. For these loans, they do not require any collaterals. The personal guarantee by business owner is not also required if you meet the two following requirements, which is if the asset and accounting are separated between the owner of the business and the business. And second, if the asset exists, the debt. So in terms of borrower subsidies that John also mentioned, for both JFC loan and loan with CZC, interest is reimbursed for the initial 3 years. For loan with CZC, since it's a guarantee system, guarantee fee is placed, but it is deducted for the entirety of the loan. I understand that in short term, these public loans are effective ways to cope with this situation, but they may not be sustainable for long term, as for example, there could be due to lack of funding, or there could be a critical eye that will be shed if there is excessive lending, which has been the case for loan with CZC, as Marek pointed out, and is also pointed out by the OECD survey. Thus, in the long term, loans made by commercial banks with collateral may come into focus. The government is considering reform of security interest over movables, including receivables. There is a committee, albeit unofficial, has already been created to consider the reform, where unstable modern law has been referred to many times, and it has helped us set guidelines for reform. Thank you very much, Madam Secretary.
Thank you very much to the distinguished delegate of Japan for sharing the experience of Japan's public sector. I would like to give the floor now to Colombia. I understand we have a speaker from Colombia. You have the floor.
Good morning, everyone. Could you hear me?
Yes, we can, loud and clear.
Okay, thank you very much, Madam Secretary. My name is Maria Jose Naranjo. I'm from Bancoldex, which is the development bank for entrepreneurs in Colombia. And what we do is we boost economic development through the support of micro, small, and medium-sized enterprises. So let me talk a little bit more about us, and I will explain the mechanism with which we have been working in this crisis. Well, first of all, we are an instrument of policy, of public policy, and we, as a second-tier bank, we work in the rediscount scheme. That means that we lend credit to commercial banks or to microfinance institutions, and they on-lend the credit to micro, small, medium-sized enterprises. So in this case, I will explain a little bit more about the experience of Bancoldex being an instrument of public policy. So in this case, we received, Colombia gave us, the government gave us some resources, and with that resources, what the bank did, we create more than 15 credit lines that we offer to SMEs and micro also through the financial system. We created more than 15 credit lines, like I said, for working capital to overcome liquidity difficulties, and the credit line have special conditions, lower interest rates and longer tenors to help SMEs to overcome this specific difficult time. There are a very specific characteristic is that in these credit lines that enhance access to finance solutions to that companies, that what we did is we agreed with the financial system that they will lower their interest rate and they will guarantee the SMEs will have lower interest rate in their credit. So in financial institutions or commercial banks, they at least they will lower 2% of the credit interest rate, and in the case of micro institutions and microfinancial institutions, they will lower 5% in the credit rate. So this is very good initiative, because as a development bank, what we do, we have to ensure that the micro, small, and medium-sized enterprise will have a credit line in good conditions, with, of course, the resource of the government that Bancoldex received in this specific moment of the pandemic. So I will tell you a little bit more about the figures. Maybe we have disbursed more than $250 million in specific instrument of the crisis, and we have attended more than 10,000 companies, and 90% of that 10,000 companies are micro, small, and medium-sized enterprises. This is the case of Bancoldex, but in Colombia we have also another institution that is the Fondo Nacional de Garantías, that is also a very interesting instrument in the crisis. And what they did is, of course, they received resources from the government, and that allowed them to increase the coverage of the warranty from 80% to 90% of the premium. And if you put together the solution of Bancoldex as a development bank and as a financial Fondo Nacional de Garantías as a warranty fund, you have a very good condition and a very good merit, I would say that way, to facilitate and to enhance the access of credit to small, micro, and size enterprises. That would be all, I think, what we'd like to share from Colombia. Thank you very much.
Thank you very much to the distinguished delegate of Colombia for sharing this insight with us. I give the floor now to the distinguished delegate of Russia. Russia, you have the floor.
Thank you very much for giving me a floor. Do you hear me?
Yes.
Just a general remark. When we talk about adoption of any measures helping to small and medium companies, we should think not only about insolvency and credits, but also take into account that these companies faced with other problems, including licenses, accreditations, permissions, state control, rent of premises, and so. And we think to help to the whole world to consider different instruments which will soften the situation. Today it has been highlighted that women, for example, do not have the access. We doubt if it's a mandate of UNCITRAL to resolve this problem and other international organizations. But this information will help us to adopt necessary measures. We should think here on what kind of measures we can consider on a legislative level to fight with circumstances raised by the COVID-19, and which instruments within the UNCITRAL we can improve. As a Thailand, Japan, and Colombia, Russia also has adopted a number of measures, and we are ready to share our experience too. In this regard, I have one question to Mrs. Menezes. She said that the World Bank is currently preparing the report on measures to help MSMEs. Maybe I missed that. Have you analyzed the measures adopted by states only in field of insolvency or in other field too? Thank you.
Thank you very much to the distinguished delegate of Russia. Maybe before giving back to our moderators in order to respond to this specific question, I could give the floor to Antonia. Antonia, would you like to answer this specific question, please?
Thank you, Secretary. To answer the honorable delegate of Russia, the World Bank insolvency team is currently preparing principles for effective micro and small enterprise insolvency regimes. These principles are used to evaluate countries' insolvency regimes and formal assessments of how strong they are. And these principles will hopefully be available in the next month. In addition to that, we have reports on our website which do indeed look at different jurisdictions and how they have addressed MSME insolvency. And I would be happy to share the link with the UNCITRAL Secretariat to circulate to the participants today. Thank you.
Thank you very much. So keep your microphone open, Antonia, because I'm giving over to you and Louise now to moderate our question and answers session.
Thank you very much, Anna. We only have one question so far in the Q&A panel on the side of our screen. If anybody else wants to ask one, please do. And I think it probably relates to my panel rather than Antonia's. So what I'm going to do is ask the question, and it's quite a general one, so I'm going to ask each of our panelists in turn to give a sort of 30-second answer to the question, or quick answer. And the question, which comes from Charla Dremel, is that if the panelists could direct the work of UNCITRAL going forward, what form of instrument or instruments, if any, would you view as most useful to address access to credit needs for MSEs? And so first of all, perhaps I can call on John to see what he thinks about that. John Wilson? Sorry, I assume John's...
Yeah, sorry, I may be on mute. Can you hear me now?
Yes, I can. Sorry, John.
Okay, great. All right, so 30 seconds. I mean, I'll use this as an opportunity, I think, to plug the work that UNCITRAL and UNIDROIT are jointly undertaking on the digitization of assets. And in particular, at least with these issues that we've been discussing on blockchain, digital technology, fintech, the digitization or tokenization of paper-based assets, or the taking of real-world commodities and being able to digitize them and trade them or use them as collateral on blockchain or other types of fintech platforms, I think will play an enormous role in creating new types of collateral for those types of borrowers that currently don't have access, but also in commoditizing a lot of the collateral that currently exists for better usage as tradable assets or usage as collateral. So I do think that this is one aspect of the joint work of UNCITRAL and UNIDROIT that holds a lot of promise in this space.
Thank you very much indeed, John. And I would very much echo that. I'm very involved in all of that, and I quite agree with it. I think it's extremely important. Marek, what do you think?
Thank you, Louise. So we have heard that secure transactions and insolvency operate within a larger ecosystem of different areas of law and regulation. And what I have seen over the years is somewhat of a limited focus of different standard setters on the areas that they are responsible for. So you would have some guidance on some regulatory aspects, some guidance on legal aspect, but it's very difficult for a state to put all of that together in a coherent fashion. So I'm actually glad that UNCITRAL undertook some work as part of Working Group 1 on a cycle of a business that brings together some of these areas. They also coordinated their work on the practice guide that you, Louise, mentioned with the Basel Committee. So I think there is a bit more of that type of coordination to the extent feasible that could be done down the road, such as with the agencies responsible for the valuation standards, or even with the governments and agencies that run these public guarantee schemes. I think to the extent that those delegations at UNCITRAL could be composed of the people who are responsible for some of these measures implemented by states, discussing them within the framework of Working Group 1, I think that would be quite useful. Obviously, the content then drives the form of the instrument, as Charla was asking about. So given the different moving pieces from different areas, I don't think this is a conventional or model law type of an instrument. Obviously, UNCITRAL has published a number of guides in the past that brought together a variety of issues together. So I think that would be the most appropriate type of an instrument. Thank you.
Thank you very much. Now I'm going to call upon Mary Ellen for her ideas, but we do have an additional question, and I think I might put that to Mary Ellen as well, because she mentioned informality in her presentation. So Mary Ellen, as well as the question we've already asked, can I also ask your views on what do you think governments can do with the informal entrepreneurs and recently born enterprises? Can we only help the formal economic sectors? So Mary Ellen, can I call on you for those two questions?
Sure, Louise, thanks so much. I think I would urge UNCITRAL to continue to stay full speed ahead on the model secure transactions law. work, but perhaps to adopt a gender lens, if you will, and to ask at each stage of working with a government, how might this affect women? And the best way to do that, and I think this is a huge opportunity for a body such as UNCITRAL that has such credibility as an arbiter in the commercial world, to really push financial institutions, push regulators towards gender disaggregated data. It is the one enormous gap in our understanding of these businesses. There are the huge minority, if you will, of financial institutions and regulators that require financial institutions to compile data on whether it be on individuals or on businesses in a gender disaggregated way. And then I thank you so much for giving me that second question. I got very excited when I saw it in the Q&A, because while I do think this work really does pertain primarily to formal economic sectors, I think this crisis is an extraordinary opportunity for governments to provide the incentives toward formalization that perhaps we don't always have. So many informal enterprises only think of formality as, oh, I'll have to pay taxes, and don't really see themselves getting enough benefits from that registration of their businesses, from that transparency or that visibility that formality gives them. This is a moment where governments really can help businesses. And so I think this is the strongest set of cards governments have had in decades to really push the formalization and really see that there is a great deal to be gained by an entrepreneur in making that shift to formality.
Thank you, and I would very much echo that in the amount of work I've done. This question of informality and formality is critically important. The other thing I would mention in this regard is the work that UNCITRAL has done and their legislative guide for business registration. And UNCITRAL has done a lot of work on the type of institution, type of legal person that can be used in business for very small businesses. We have one more question, which I think I can ask. I hope I can ask. Very briefly for John, is a question from Fosca Agola, who asks, is it not possible for the World Bank Group to lend funds directly to private companies and individuals of different countries for MSMEs? John, can you be very brief on that? Is there a brief answer?
Well, it's not possible, obviously, for bank to lend directly for the World Bank to lend directly to individuals or even companies. It is possible for the International Finance Corporation, which is a part of the World Bank Group, to do lending that's directed to the private sector, but it's usually second-tier lending that goes through financial institutions, and then some equity financing that does go directly to this private sector firms. But for the most part, obviously, the type of assistance that we were mentioning through development policy loans or COVID response loans goes to governments from the World Bank. And from IFC standpoint, it goes directly to other financial institutions that then do onward lending to the MSME sector. Thanks.
Thank you very much. Thank you, everyone, for your great questions. I'm going to hand back to Antonia now for some final words from her panel.
Thanks, Louise. Maybe one question to either Kat or Jason. As we know, and Kat mentioned, a large number of MSEs that are going to go through insolvency will most likely have no income and no assets. And how should these cases be dealt with, do you think, in MSE insolvency regimes, particularly given that in many countries, they won't have the resources to administer the cases themselves?
Right, so this is a very tough question, and dealing with no income, no assets, and importantly, a qualified MSE debtor. That's really tough. And essentially, you're looking at a very simple, very quick discharge. So you want to make that as cheap as possible to get through the system. But it's not completely cost-free. So who's going to pay for it? One option is to make larger restructurings pay for it. In certain jurisdictions, the larger the restructuring, the more distributions, the more you pay into the system. This can subsidize the smaller restructurings for 99%. And the reason this is an attractive solution is because some of these entities are using the insolvency regime system to reduce debt and right-size their footprint, but otherwise have sufficient funds to pay for the restructuring and a little bit extra. The other possibility is that the state would need to allocate funds to finance these cases. The reality is that if there's no income and no assets, there's no incentive for the entrepreneur to file and pay for it. And if you want these entities to be flushed from the system, which we think you should want that to occur, then you need to encourage and provide a way to pay for that. And that means someone else is going to need to do it.
Thanks, Kat. Yes, I completely agree with that. Jason, any final words for countries that are looking at designing effective MSE insolvency regimes?
I think the only final thing with which I would close is to emphasize something that Kat just mentioned, and that is the idea again of incentives. If we want these MSME entrepreneurs to be engaging the system, we have to offer them something to bring them to the table. And that thing inevitably has got to be a discharge of liability. That is the principal relief, the principal purpose that a small entrepreneur will be seeking and needing from these kinds of systems. We simply have to make accessing that relief non-complex and inexpensive. And again, we very well appreciate that fear of abuse, fear of hidden assets, fear of whatever machinations we might be afraid of is a powerful inhibitor of states around the world from allowing too large a number of people to be moving through the system and being relieved of their honestly contracted debts. The fact of the matter is, the milk has been spilled, and arguing about who's responsible for the spilled milk and what to do about it is not an effective way to move forward. We've got to get people the relief that they need inexpensively.
Thank you, Jason, and thank you, Kat. I think we're out of time for additional questions on our side, so I will hand it back to the Secretary now. Thank you.
Thank you very much, and to all participants, thank you for having joined us in the third day of our series of webinars. I think you all agree with me that we had two excellent panels with excellent speakers who have addressed these two topics that are different but related topics from various angles. And our thanks to them and to the two moderators, Antonia and Louise, also to Mahesh for his introductory remarks, Jason, Kathleen, John, Marek, and Mary Ellen. Also was interesting to listening to them also again to see the connections to the overall thread of our series of webinars, the reference to the importance of identification in digital identification, digitalization of assets, and developing electronic commerce agenda. We'll be getting to dispute resolution in 2 days from now, and then to the gender issues, the last day of our panels. Join us tomorrow for another panel on a slightly different topic, but then again, there are some allusions made to that, and that is the impact of COVID on public procurement and PPPs. That connection may not be so evident, but there is a huge pressure on governments to ensure the availability and continuity of public service, and COVID, of course, puts a significant stress on public service providers, as well as it puts pressure on governments to procure new services under extreme time constraints, and then to find a balance between proper procurement and emergency situations. That, of course, has a lot to do with some of the things we heard today about emergency support packages that governments are making available to support MSMEs, but also other areas of the economy through the crisis. Again, I believe I speak for everybody in thanking the panelists for their excellent presentations and look forward to seeing you with us again tomorrow. Thank you.